Drafting correspondence is an integral part of your everyday lawyering life. For example, I was just about to draft a letter. Let's talk a little more about drafting your own correspondence. We'll start by talking about three types of correspondence. First, there's the demand letter. Next, the client letter. And finally, the settlement demand. We'll take each separately. As for the demand letter, this document truly has an attorney walk a fine line between indicating that you mean business, but yet you are a reasonable sort. In our business, you use the demand letter to avoid litigation and settlement matters prior to engaging the courts. Before drafting the letter, you need to make the following decisions. Number 1, explain what demands your client wants you to make. Number 2, explain why this action is necessary. Number 3, explain all acceptable alternatives, if any are applicable. And number 4, give a date certain when the proposals in the demand letter require compliance. Your professor has assigned you to draft a demand letter. You will be writing to opposing counsel to try to stop his client from continuing to defame your client. This letter generally invokes an all-or-nothing tone. This means that the attorney drafts the letter forcefully enough to evidence that he will go forward with the next appropriate steps, meaning filing a lawsuit or seeking a temporary restraining order, should the letter's receiver fail to comply with the demands. That being said, your tone should not be overly aggressive to the point of being obnoxious. Finally, make sure that your demands are reasonable so that compliance is feasible and that the chosen compliance date is reasonable as well. You should send the letter via fax, certified, registered mail, or overnight express delivery, or perhaps hand delivery. Only if immediate change is warranted should you send a letter via email. You want to ensure that your opponent has received the letter and know when he received it. Generally speaking, you'd like to format the letter accordingly. Number 1, use your firm's stationery. If you don't have it, create it for your writing assignment. Number 2, indicate how you are sending the letter. By example, certified mail. Number 3, state the topic of the demand letter in the regarding line after the addressee, but before the salutation. Number 4, provide your formalized salutation. For example, use Mr. or Ms. instead of the first names and end with a colon, not a comma. Number 5, discuss the facts leading up to the need for a change. Number 6, state the basis for the demand. Number 7, make the demand. Number 8, give the final date for compliance. And number 9, end with a signature line. The second type of correspondence to discuss is the client letter. Not only do we as attorneys have an ethical duty to keep our clients informed of the status of our representation, but you also want your client to be kept abreast of your service. This can alleviate questions of billing and questions of overstepping authority, especially where clients want approval for attorney actions. Remember also to tailor your letter to the sophistication of your client. If you are a corporate attorney reporting to only a handful of people who have dealt with identical or similar legal situations on a frequent basis, say the vice president of a corporation who is familiar with legalities, then you don't need to explain every concept or step for the process. However, if your client is either unfamiliar or less familiar with legal processes, then your focus will be on ensuring that he understands what has transpired, how you intend to proceed, and possible end results from those actions. Offer your client alternatives, if necessary, but remember that you are not only an attorney, but a counselor as well. Counsel your client on the best alternative, keeping all financial interests outside of the equation. As for the format, it is similar to your demand letter. You need the following. Number 1, use firm stationery. Number 2, indicate how you are sending the letter, either via email or U.S. mail. State the topic of the letter in the regarding line, either a case or file number. Provide your formalized salutation. Number 5, discuss the status of your representation. Number 6, counsel your client on the proposed future avenues. And number 7, end with a signature line. Finally, let's discuss the settlement letter. This letter is to opposing counsel to indicate your client's offer to settle ongoing litigation or proposed litigation. It is very similar to the demand letter, but it is not as demanding as the first. The letter indicates the offer that your client is willing to accept in order to settle the action. The biggest difference here is that this letter, although unstated, generally is not take it or leave it in terms of an offer. It should invite your opponents to make a reasonable counteroffer. Traditionally, you don't want to start off with a final offer unless your client specifically instructs. If it is a final offer, then you need to articulate this in the letter, especially if the parties have previously entered into negotiations. Once again, the format is similar. Number 1, use firm stationery. Number 2, indicate how you are sending the letter, again via U.S. mail, email, or facsimile. Number 3, state the case name and offer of settlement in the regarding line. Number 4, provide a formalized salutation. Number 5, discuss the facts in the light most favorable to your client, which warrants the figure you will request. Number 6, make the offer. Number 7, justify the amount sought. Number 8, give an open date in which your client is willing to keep the offer open. And number 9, end with a signature line. Well, I hope you've enjoyed your foray into correspondence. Although unseen on most lawyer TV shows or movies, this plays an integral part of our daily work. Speaking of which, I need to get back to my work.